Just what, $1,000 a day penalty if they didn't?
They never informed the Greystone or any of the defendants that this was out there.
Basically, I stayed on because I knew Monster was going to screw this up, is what it comes down to. And John Cook never showed up to the hearing. I didn't even know that happened.
Knew there was a hearing and you didn't go to the hearing, right? What do you mean you're new at this?
I'm new to having a shakedown happen to me in court.
The sanction ought to be $20,000. Okay, well, let's get started. Ms. Hayes, I'll call clause number D1GN 24001975. Style Brianna Wilson versus Greystone Custom Homes et al. Ms. Amy Wellborn is here for the movement on a motion to reconsider from a year ago. Mr. Jason Billick is here for the plaintiff. And who else is here?
This is Chad Cotton, Your Honor. I'm here for the Monster Law Firm.
Monster. Oh, yes. We have a Monster and a, what's the other one?
That would be me. I'm here as a witness for the movement.
Neuro something.
Neurospicy Legal.
Yeah, what an odd name. I don't think I would ever hire a lawyer who called himself Neurospicy.
It's a millennial joke.
I don't even know what that means. I'm Neurospicy.
It means neurodivergent, like ADHD.
Oh, okay.
Yeah. It's a joke.
Ha ha.
Yeah.
Okay. I see that I signed a contempt order on March 3rd of last year. At that hearing, a departing attorney appeared and the incoming attorney did not appear. The departing attorney asked to be excused from the case. I excused him. He went away, and I was left only with the movement to tell me about what was going on. So I granted a motion for contempt and set a punitive incentive for the defendant to answer the discovery that had been pending for months and months, and assessed what, $1,000 a day penalty if they didn't. So we're met here on a great battlefield of that war to test whether that's a good order or not. Ms. Wellborn, you say it's not?
Your Honor, I don't usually say things, but yes, in this case, I have a just very simple point, and I think that there probably are sanctions that should be awarded. However, I don't think that Mr. Greystone and Mr. Johnson are the ones that should be responsible for that. And if you let me share my screen, I have a quick PowerPoint I can go through if you'd like.
Sure.
Okay.
Share it.
Oops, I've requested.
Got to tell you, Ms. Wellborn, I've always been envious of your name. I mean,
It's a politician name.
She's well born. Yeah.
See if I can get this to play properly. Okay. All right. Well, I'm just going to go through the slides like this to save time. But as you can see, we had a motion to reconsider the sanctions. The discovery was actually sent, and I'm basing this on the documents that I've seen because I was not counsel at the time. But the discovery was served on August 28th, and we've got Mr. Johnson here on behalf of Greystone to testify, but he's going to let you know that the discovery responses were actually sent to the Monster firm on September 18th. On December 10th, the motion to compel was filed. Greystone did not get notice of this. On January 22nd, the order granting the motion to contempt was entered, and then the responses were due by 5 p.m. Monster was the original counsel for Greystone. On December 10th, they did file a motion to withdraw. And as you stated, that motion was granted on March 3rd, right before the sanctions order. They never informed the Greystone or any of the defendants that this was out there. They never informed them that discovery had not been served because they had answered the discovery and sent it to their counsel for them to be served on the other side.
Greystone filled out the discovery and sent it to the Monster firm?
Yes, Your Honor.
It
yes.
never got filed.
And it never got filed. But they were not aware of that.
Or never got sent, I guess. We don't file it anymore.
They were not aware that it wasn't sent. They weren't aware that there was any outstanding issues. They weren't aware of the motion for contempt hearing. They weren't aware of the motion to compel hearing. And they were not aware of the sanctions.
Why was their new lawyer not at the hearing or never made an appearance of any kind?
I have him here to testify today, and I can ask him specifically why he was not there.
That'd be a
Mr.
good
Bishop,
idea.
Mr.
Yes.
Bishop, can you tell us a little bit about what happened with that hearing?
Right. The March 3rd hearing or the January 22nd hearing?
March.
Let's start with the January 22nd and then go to the March one. Because I know
January
you had
22nd.
you'd previously been employed by Monster, correct?
Yes, I'd been employed by Monster and had worked on this case.
Okay.
And
So-
so when I left Monster, Greystone decided to come with me. And I felt kind of an obligation to them because of where they were at in the litigation. Basically, I stayed on because I knew Monster was going to screw this up, is what it comes down to. I knew something like this was going to happen, which is why I've also stayed on the case, on the listserv for the last year and a half. So I had sent over, while I was at the Monster firm through office email, Outlook, to the previous attorney, Josh Crowley, a big packet of discovery that Greystone had provided that we did have. And then I included a little index in Microsoft Word of what parts were responsive. I just gave him this whole thing. And I leave Monster.
Is that the giving that took place in September of 24?
Yes, Your Honor.
That where it says Greystone sent, can't read the rest because it's so small, sent their discovery responses to the Monster
Yes.
firm. That's you sending it?
Yes, through my my official Monster email. Email to email, point to point with the previous counsel for the plaintiff. That would be Josh Crowley, I believe.
Had you left Monster at that time or you were still there?
I was still at Monster at that time when I sent the discovery responses directly.
Sent the discovery responses to the attorney in charge of the case?
No, I sent them directly to Attorney Billick's predecessor at his firm.
Who's Attorney Billups?
The attorney for plaintiff.
Oh, Billick.
Jason. Yeah.
I was hearing you say Billick. Yes. You sent them the responses to Billick.
Using directly with Outlook, yes.
Okay. And he's the plaintiff's attorney.
Well, yeah, to Josh Crowley, who was the plaintiff's attorney at the time. Attorney Billick came in the next month.
Okay. Josh Crowley in the same firm? Or?
He was at the time, yes.
So your position is they got the discovery?
Has been, Your Honor.
There was some issues with what was served, and that's when the motion to compel was then filed. Was my understanding from speaking with both Jason and looking at the documents. And then at that
I remember seeing something that there were some documents, but that wasn't fully responded to.
Yes, Your Honor. And so then can you tell us about what happened at the first hearing, Jake? Mr.
Right.
Bishop?
And this is what I meant about how I knew that something was going to get screwed up, because they weren't complete. The responses were not complete at the time from when I was saying I still owed interrogatories, I think. It's been a while. I'm pretty sure I am owed still in interrogatories, or one of those is what I still owed. It's been a while. I've slept some since then. So January hearing comes around, and I've been in contact with the actual Monster attorney, who was my senior attorney at the time, John Cook. And I had been doing a lot of work for him on this case and others, doing a lot of his writing and whatnot. And I message him and say, hey, you've got a hearing tomorrow. I just found out about it. This is a very original motion to compel discovery. And my point was, hey, they've gotten some discovery. They haven't gotten all of it, but they're claiming they haven't gotten any of it. So I hand this stack of emails between myself and Attorney Billick over, where I'm referencing things in the discovery, like, hey, this is what I'm going to use in this litigation. We're not going to settle. And just going down the list and taking screenshots of the big packet he was sent. And had no idea there was a motion to compel discovery. And I find out from emailing him, say, hey, did you get that second thing that I sent you? Because I was trying to follow up and complete the discovery. And I hadn't gotten a response from him for about a week. And
this is more testimony than I thought you were going to give. Raise your right hand, please.
Sorry, Your Honor.
You solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
And the testimony you previously given.
Yes, Your Honor.
All right. Go
Cool.
ahead.
All right, where was I? Oh, yeah. So I wasn't on the listserv, so I didn't even know about the hearing. I email Attorney Billick and say, hey, did you get that thing I sent you earlier this week that had the discovery in it? His response was effectively, yeah, I'm still going to go ahead with the hearing tomorrow, because it was not complete to his satisfaction. And I alert Attorney Cook, say, hey, because I'm in Dallas, this is in Austin. I find out the day before. There's no way I can make this hearing. But Moster are still the attorneys of record. So
where's the Moster firm located? Austin?
John Cook lived in Austin. Yeah, he was their local Austin attorney.
Go ahead.
All right, so I send that text message. He acknowledges. We talk. I get up early that morning. I send him the files that I had on saying, hey, the discovery's not complete, but his argument's wrong because we've sent some discovery. And John Cook never showed up to the hearing.
And so then the order was entered, I assume. And then can you tell me about what happened with the next getting any documents to Mr. Billick? Meantime.
So I again got the documents that were necessary, sent them to Attorney Billick, who had still not stated the specifics of what was missing, aside from the interrogatories, which I knew and sent, but I suppose they weren't to his satisfaction. The March 3rd hearing, where the motion to withdraw, I didn't even know that happened.
And you were not representing the defendant at that time, or you were?
Not at. I think March 3rd is when I started. I think that's when they finally withdrew. When Moster finally withdrew.
Okay, so you are now the attorney for the.
Yeah, I kept them on the hook for exactly this reason, because I knew that this was going to happen. Something like this with the evidence with the handover. They refused. Moster had the emails showing that I had sent this, but they wouldn't give them to me. To date, I never received anything from Moster on the client's file, and I don't know if Ms. Wilburn did either.
Okay, and so then why didn't you attend the contempt hearing?
The contempt hearing I didn't know about. If it's the March 3rd one you mean?
Yes.
The one with the withdrawal, the actual withdrawal?
Uh-huh.
Correct, yeah.
Okay, and how come weren't you notified of that hearing?
Because at that time I was on the listserv. I would have been on the listserv. Oh no, I don't think I'd gotten on it yet. I must have not been served on the listserv. My memory's fuzzy on that one. I can't swear to whether it was that issue or whether I was told by Moss. No, I can't remember the conversation. I must have not gotten the serve.
Okay. And Moster was still the attorney of record until they withdrew right before that hearing.
Yes.
Okay. Okay. And do you have anything else you want to add to this?
No.
Okay. Then at this time, I would like to call.
Can I ask some questions?
Yes, sir. Go ahead.
Oh, yes.
You are Mr. Cook?
Cotton. No, I'm Mr. Cotton.
Okay. With an E.
Sir, Mr. Bishop, you were the attorney representing Greystone
When
you were at Monster Firm?
No, that was John Cook. I was his subordinate, and I was doing.
Were you working on the case?
Yes.
Did you prepare discovery responses?
Yes.
When did you leave Monster?
November.
Of what year?
2024.
Did you quit or were you fired?
Oh, I was fired.
What for?
For raising concerns about unethical billing practices.
How many, you took Greystone as a client. Did they approach you or did you approach them?
They approached me. That's how this works.
When did you sign a contract with them or did they sign a contract with you?
God, I don't know.
I don't understand the question.
Yeah.
Yeah, Your Honor, I'm laying a foundation for when he was actually working for them as a lawyer.
Well, you sign a contract with each other. You don't sign one.
I'm trying to find out when he did.
Okay, ask the question then.
I don't remember, but it was at some point, I think after I left, it might have been December, there was the original retention of me, but I still was not representing them in this case until much later. I was not officially entered as their attorney of record.
But you were working for them, correct?
Yeah, which is why I sent John Cook the stack of stuff he needed to prove that we'd provided discovery.
And we haven't seen that email of the stack of stuff you say you sent him.
No, because Monster refused to provide it. Although you can see in
we don't. What do you mean they refused to provide it?
They refused to give me access to my old emails because Monster was worried about the things I was saying.
Who did? Who
Charles
refused?
Monster.
On the phone?
No, he was not letting John have access to any of my old emails. He was still the attorney of record.
Okay.
He was keeping it cloistered with him and his wife because I was raising issues about unethical billing practices. So he was doing damage control.
On December 10th, 2024, there was a motion filed to substitute counsel, and you signed that motion, correct?
Mm-hmm.
Is that a yes?
Yes.
So on December 10th, you were aware that you were going to be that you were representing them and that you were trying to get substituted as the counsel of record.
Which is why I was actively emailing Attorney Billick the entire time.
What were you doing to get that order signed by the court?
John Cook was the attorney of record living in Austin. He was supposed to go in and do a handoff.
What did you do?
I communicated with Attorney Billick repeatedly and provided the discovery that he asked for.
What did you do? Did you call the court, ask them to sign the order?
No.
And you knew about the hearing in January, the day before, correct?
Correct. The day
You're in
before.
Dallas?
Yes.
How long does it take to drive to Austin?
Too long because I had something the other day already.
Did Mr. Cook ever respond to your communications about the hearing?
Yes.
What did he say?
Haha. Oh yeah. Right. And then he asked me like, "Hey, send me the email, the file on Greystone about 5 in the morning. That morning, 5:30.
We don't have that email either, do we?
You do. It's actually a text message.
It was an email to you.
No, this is a text message.
To you, but where's the text message? You have it?
Yes.
Where is it?
I will
Ms.
note
Walter?
that I filed it with the court last night.
I'm sorry?
I did file his affidavit or declaration, and that text message is attached to it. And I filed it with the court yesterday.
So you were representing them at the time. You had been hired as their lawyer. You knew there was a hearing, and you didn't go to the hearing, right?
Nope.
How is that not right?
Because I wasn't representing them in this case.
Yes, you were. You had already agreed to.
Is that a question?
Yes. Tell me how you weren't representing them when you already have an agreement to represent them.
Because Attorney Billick didn't serve me. And his entire argument was that I hadn't been entered as the attorney of record in the case. If you want to yell at somebody, yell at him for not putting me on the listserv.
Who prepared the original discovery responses?
The ones that I sent Attorney Crowley?
Mm-hmm. Yes.
I did.
So you were the one who didn't respond properly.
It wasn't improper response. It was lack of response.
Okay. Why didn't you put yourself on the service list for the case?
Because I'm new at this. And I was directly communicating with Attorney Billick.
What do you mean you're new at this?
I'm new to having a shakedown happen to me in court.
What do you mean a shakedown? Who's shaking you down?
The sanctions motion was only filed after I told Attorney Billick I wasn't going to settle and then showed him exactly what I was going to use in litigation.
So who's shaking you down?
I mean, they were trying to shake the client down.
Who?
Greystone. Greystone was being shaken down by the other law firm.
Which one? I'm just trying to get a response on the
Attorney Billick's.
Thank you. Okay, that's all I've got.
Anything else from anybody? Is
Your Honor. I'd like to call Mr. Johnson.
that your client's representative?
Yes, Your Honor.
Yes,
Raise your right hand, please, sir. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Johnson, can you state your full name for the record?
Jerry Dean Johnson.
And what is your role with Greystone?
I'm the managing member of the LLC.
Okay. And were you in charge of overseeing this litigation?
Yes,
And were you also personally sued in this litigation?
yes,
And did you hire Moster to represent you in this litigation?
yes.
And did you receive any discovery to answer?
I did in, I believe it was August of 2024.
Okay. And when you received this discovery, what did you do?
Prepared responses in entirety and emailed that to the Moster firm in a complete package on September 18th of 2018.
Okay. And did anyone?
Sorry, 2024. I'm sorry.
Okay. And after after you sent that to them, did they ever tell you that there were any issues or any additional documents that were needed?
No,
Did you ever hear anything else from the Moster firm with regards to the discovery?
no,
Okay. Were you aware that a motion to compel was filed on December 10th?
no,
Did the Moster firm let you know this?
no,
Did Mr. Bishop let you know this?
no.
Okay. And at some point you asked the Moster firm to withdraw, is that correct?
Yes.
And why was that?
We just were not really being communicated with and didn't know exactly what was going on. We just decided we needed to go another route, and that was I emailed Mr. Moster himself on December 10th of 2024, and he responded that day, and he said he understood, etc., and he would file the proper paperwork, etc.
And how many attorneys had you had at various times working on your case?
I believe there was 5 different attorneys in his firm that had worked on the case.
And did they all work at the same time, or was one of them quitting and another one coming?
It was in succession.
Okay. And so,
may have been 4 attorneys. Yes.
okay. And so then how did you come to end up working with Mr. Bishop?
Mr. Bishop was communicating. He was working for the Moster firm at the time, and he was our attorney of record the way we understood it. We didn't know, didn't even know John Cook, and had never spoken to him, didn't know he was on our case. But Jacob was communicating well. And so after we decided to switch attorneys, I approached him. I had his cell phone number, was the only thing I had. So I just approached him to talk about the case, and eventually decided to hire him.
Okay. And at some point you switched to me representing, is that
Yes,
correct?
yes.
How was it you came to have me represent you?
I received a phone call from you concerning another case, and then I had mentioned this case to you, and we, liked kind of working with you. So we decided to hire you on this case as well.
And when did you first learn that there was an issue with regards to discovery?
It was from you, and it was after, it was a conversation we had on the phone, that you said that you needed to talk to us. You had just found out something, and you told us that we had a $160,000 fee that we owed the court, and that was the first we were aware of any kind of sanctions or anything. That would have, I don't know when that would have been, but it was enough to accrue $160,000 of $1,000 a day, apparently.
Okay. And had you been notified that there was a hearing on the motion for contempt?
No,
Had you been notified, did any of these attorneys send you an order stating that there was a contempt order in place?
no,
Did any of these attorneys ever reach out to you and ask you to help organize discovery or to respond to discovery that was outstanding?
no.
Okay. At what point did we then work to get the discovery amended?
I will say to the last question, I did rescind the discovery to Jacob after he had left the firm because he said that the Wilson's attorney's firm had not received the discovery. So I sent it to him again, and then that was to clarify the answer to the previous question, and then the next question was.
How was it that you ended up actually supplementing the discovery? What attorney did you work with to do that?
That was you.
Okay. And so until I came on, you didn't know anything about this.
No.
I'll pass the witness.
I have no questions, Judge.
When did you decide, do you remember, sir, when you decided to go with Jacob Bishop? Was it November or December of 2024?
It may have been in January of 25, actually. I don't recall, but it was a time after we had asked Mr. Moster to withdraw. It was several weeks at least after that, and that was on December 10th of 24.
And who was your contact at Monster Law when you decided to no longer maintain that relationship?
It was Charles Moster.
Had you spoken to Mr. Bishop before?
Yes, yes.
You said there were issues with communication. Who was it that wasn't communicating?
Well, I was getting no it wasn't that I wasn't getting anything from them. I didn't know what was going on. And
Excuse me,
from the Moster law firm. Yeah. And I mean, after we filed or sent the discovery on September 18th, we just kind of thought things were going fine, and we were hearing nothing, et cetera. And then I believe Jacob may have asked me to, I don't know. Jacob was communicating with me. I really don't recall it exactly. And then I don't think I'm answering your question, but could you, if you repeat the question again, I'll try again.
That's okay. It's probably a bad question. Do you remember who at the Monster Law Firm specifically you sent the discovery to in September?
It was to Jacob at mosterlawfirm.com. I've pulled it up. I still have it.
Okay, I pass the witness.
One final question. Had you had much experience in being a party to litigation?
No. In fact, we had to interview attorneys because we did not have an attorney.
Witness.
I have
So,
no questions.
so if I can share my screen one more time. Go back here. As we've shown, there was no knowledge that the questions and that the discovery hadn't been answered on behalf of Greystone or the defendants. There's no answer. They had no knowledge of a motion to compel. They had no knowledge that nothing had been produced, or that only limited items had been produced. They were never told that there was a sanctions hearing, and they were never even told of the sanctions. The first way I learned of it was when I picked up the phone to call Jason to ask him some questions about this case, because I had another case involving the same his client, and I wanted to see if he was representing them. And that's how we first learned about it. And I went back to them to let them know what was going on. So then we worked together for us to get the discovery to him as soon as possible and to get everything done and to deal with it. But for discovery sanctions, first and foremost, you have to show that there's a direct relationship between the offensive conduct and the sanction. In this case, our clients didn't know anything about it. And so it's not only excessive, but it's also, it doesn't really help the sanctions and the penalties. It's considered a very severe penalty to award $160,000 in sanctions because my client didn't even know that there was any of this out there. And it wasn't my client that was the one that wasn't responsive. It was actually, as we've kind of seen, a breakdown between the communication between the Moster firm and Mr. Bishop, who was working for them and then was fired and then was trying to take over this case. And there was just this huge communication breakdown where I believe that Greystone became the victims of that problem. And so while we don't agree that there should be sanctions against our clients, I understand that Mr. Billick had to work very hard to get these items, and that he faced a lot of non-responsiveness. But I would argue that if sanctions need to be awarded for the time Mr. Billick had to spend, that they not be awarded against the Greystone and the other defendants, but that they be awarded against the law firms whose communication caused these issues.
Thank you. Mr. Billick, I have
Morning,
wondered-
Judge.
I have wondered over the years that this case has been before me. What's this case about? There's
Your Honor.
something about the proportionality of the sanctions, and I wondered, is this $1 million case or a $500 case?
This is a lawsuit. This is a business dispute between a former employee and joint venture, my client, Brennan Wilson, who worked for Greystone. Greystone was in the business of, I don't want to say construction, buying and flipping homes, real estate investment. And he worked for Greystone for a number of years. And a dispute arose between the two relating to his compensation, bonus structure, and the like. Obviously, the parties disagree as to the extent of that liability. The damages involved are around somewhere between $500,000 to $1 million based on various statutory damages. I know Ms. Wellborn will probably disagree.
I know Ms. Melbourne believes it's a $500 case.
Probably.
Absolutely.
But, Your Honor, if I may, I understand Greystone's primary argument for reconsideration is that the sanctions award was not their fault, or the lack of communication was not their fault, and they're trying to place all blame on their lawyers. Well, I'll be frank, I don't know what the Moster law firm or Neurospicy Legal said or didn't say to Greystone. I wasn't there. What I do know is that it took me 10 months, multiple emails, multiple phone calls, multiple motions to compel, a motion for contempt, all to finally complete an initial round of written discovery. And yes, I had an associate working with me at the time, Josh Crawley, but I've been involved in this case since day one. It wasn't until Miss Wellborn's appearance, which was basically a year after we filed suit, when the case got back on track. And in fact, her involvement and the fact that I was so happy that we were finally getting some traction, what prompted me to agree to a Rule 11. A Rule 11 that basically stopped the daily sanctions penalty award. The number 160 has been thrown around. I believe it's 119, but either way, if that's $1,000 a day, we can do the math. If I may, let me just highlight the chronology of events, because there's been a lot of talk today about what I was looking for or not looking for. And I lay this out in my response, and so I'll try to be brief. But we sent out written discovery on August 28th, 2024. On September 27th, 2024, Mr. Bishop's correct. They produced some documents. Great. But I didn't get written responses. No responses to the production request, no responses to the admissions, by the way, and no responses to interrogatories. Woefully deficient. So I sent a discovery demand letter, as I'm accustomed to do. I said, please, Mr. Bishop, give me everything else. We never got anything. That was ignored. I don't know if it was Mr. Bishop's fault or Mr. Cook's fault. Either way, Moster was the only law firm involved at the time. So on December 10th, I filed my first motion to compel discovery responses. In response, and this is what's interesting, in response, they don't give me my discovery and said it's a motion for substitution of counsel. All right, fine. I get nothing. We have a hearing. The court signs the order on the motion to compel. No one shows up. The court orders them then to provide responses by later that month, no later than February. Greystone, again, ignores this. At least I'm assuming Greystone's ignoring it. And so I'm sending emails. I'm trying to call Mr. Cook. I never once spoke to Mr. Cook in this case. He never responded. At least Mr. Bishop was able to respond multiple times. And there are emails where he says, well, what do you need? What do you need? And I clarified what it is that we need. We need the process to be complete. Admissions are past due. All the admissions are deemed, by the way, at the time. Interrogatories are not due. I have no responses to production. So I have no choice to file a motion for contempt. No one shows up. Well, Mr. Cook shows up. More on that in a moment. No one shows up, and so we get the order. And then what's wild is we provide courtesy copies of the order. I'm sure the court provided a copy to all parties, but we went ahead and provided courtesy copies anyway to let them know, hey, you're on the hook for $1,000 a day. Give me the documents. And nothing happened.
Provided a copy of it to the Moster law firm.
Moster law firm, Mr. Bishop, everybody. Right. Assuming that Greystone's aware that they're on the hook for $1,000 a day. Nothing happened. Weeks, months go on. My clients tell me, hey, just let it sit. The clock's ticking. And then finally, Miss Welborn calls, and I'm like, you know what? If we can reach an agreement to get me the documents, I'm happy to cut off the bleeding. Now, Your Honor, again, I don't know about misconduct between Greystone and their lawyers, but I will say this. The one example that I have that raised a huge red flag for me was the day of the hearing when I reached out to Mr. Cook and said, hey, we're having this hearing. I'll give you one last opportunity. I'm willing to pull it. I sent him an email, doesn't respond. Instead, he shows up, not to argue, not to do anything other than, hey, Judge, here's the order. Let me substitute and get the hell out of here. And then as soon as you signed that order, Judge, he was out. I don't know about you. I don't know how everyone else practices.
I remember that. That's the only thing I remember about the case, but I remember bang, gone.
Right. And I don't know how everyone else practices law, but if I'm withdrawing on a case, and believe me, I've withdrawn on plenty of cases, and I have a pending contempt order or contempt motion hanging over my head, I'm probably going to address that first before I withdraw to make sure that my client is in a position where they can have sufficient time to go find other counsel and they're not dealing with any nonsense like dispositive motions or contempt orders or anything like that. So to me, that was telling. Your Honor, our response provides that chronology for you in case you need detail. We believe the sanctions are just given the conduct. The problem is I have no personal knowledge. I have no evidence to indicate that Greystone to refute anything that Ms. Welborn's saying because I wasn't there. I wasn't privy to those discussions. And so my request to the court would be, if you feel inclined to believe Greystone's events, I would ask that the order be amended to include the prior law firms, but also include Greystone. And I guess I'll be generous. One of the other things I'll ask is I would want a deadline on payment of those sanctions. And I guess 60 days is fine. I think that's more than enough time for the penalty to be paid. And again, I believe I'll say this on the record, and I could be, my math is wrong, but I believe the sanctions are 119,000, which began from the day you signed the order, which was the day after, to when Miss Welborn and I executed that Rule 11 agreement. So the party should be able to easily calculate that amount. Thank you, Judge. Thank you for your time. Thank you for our patience. And thank you for allowing us to appear via Zoom today.
And Your Honor,
Give me a rough estimate, Mr. Billick, of how much in attorney's fees you have expended trying to get this discovery done.
Well, I need to look. I can tell you what the attorney's fees are today. If let me see here, because I have Clio open in front of me, which is great about Zoom.
Not your total attorney's fees, but just the one.
I get that, but that'll kind of give. So I have to go back in the motion. I know for a fact it's been at least 10 grand for the initial motion to compel, the initial process, and then when we got to the contempt hearing, I want to say our motion articulated how much we had incurred to date. Your Honor, I'd probably say somewhere in the neighborhood of 10 to 20 grand. But that is a loose estimate.
I understand. Okay, Ms. Welborn, you had questions for Mr.
yeah, I would just add that I would argue.
I mean, he's not on the road, so you're really just going to argue, I guess.
I would just argue that if there are any sanctions, that they not be awarded against my client and that they do be awarded against the law firms. I think you could see the communication breakdown just in their questioning with one another and see that my client was really just a victim in their issues amongst one another. So,
Mr. Cotton, what do you have to say about this?
Well, for the record, I would say, first of all, that the master firm was not representing Greystone at the time that the sanctions were awarded. I will also say that the relationship between Master and Greystone, it began to separate at least at the beginning of December, and that an agreed motion, and I think that's very key, an agreed motion to substitute was filed on December 10th, 2024. And that's some time before any of this happened. What that shows is that Greystone did have other counsel. He signed, because the other counsel signed the order. it doesn't, obviously, it doesn't relieve the lawyers themselves of their ethical responsibilities. Although I don't think we're here to argue that. The key is they did have other counsel. That other counsel knew about the January hearing and just couldn't figure out a way to get there. You could figure out a way to do almost anything, Your Honor. You can at least call the court and ask for a continuance or a brief one.
When you're not attorney of record?
Well, you're still their attorney, though. I know he's not attorney of record, but you're still their attorney. So yes, you can, because that's pending before the court. I mean, no action was taken to try to get that substitution order signed. It had been pending for 2 months at that point. I take that back, a month at that point. Then to not put yourself on the listserv because essentially what I heard counsel say is he didn't know what he was doing. So he didn't put himself on the listserv and didn't know about the sanctions hearing. The point of contact, I'm not here to defend Mr. Cook or his conduct or his behavior. He's no longer with the firm, obviously.
Seems to be true of a lot of people.
Well, and this isn't the first situation where I've had to come into court and deal with cleaning up a mess that Mr. Cook has made. So at the time the sanctions were actually done, the Moster firm was no longer involved in the case. Before that, no sanctions had been awarded yet. They just hadn't been. And that's what the record says. I'm not sure legally if you can even go back after a substitution of, I don't know, it's almost a year, it's more than a year, and try to sanction somebody for discovery when that didn't happen during the time of the actual representation on the record. I also think that $100,000 or $1,000 a day is excessive. Let me say this, Your Honor. If I'd been at that hearing, I promise you that those discovery responses would have been served that day. I wasn't. $1,000 a day is excessive. And it would be excessive, I would argue, in a case that was worth a lot more than what we're talking about here in this case. I would also point out that there was an attempt to respond to the discovery. It's not like it was just totally 100% ignored. So, I don't think legally the Moster firm can be saddled with these sanctions more than a year after they withdrew from the case. That also happened after they withdrew. I understand the course of events that
the behavior for which the sanctions were being assessed occurred when Moster was the attorney of record.
Well, no, because the sanctions were assessed from that point on, $1,000 a day. There were some sanctions awarded of I think a couple $500 and maybe $3,000 in attorney's fees. The sanctions that were actually asked for in the motion, that's one thing because it was past behavior, but the $1,000 a day is going forward when Moster's not representing them anymore, and they have counsel.
And I do want to note that those attorney fees, Moster Law Firm sent those sanction bill to Greystone and asked them to pay it directly to Mr. Billick's firm, for which they did.
Which they did.
And I'm not sure what I don't know what that amount is.
What do you mean, which they did? They paid the sanctions?
Yeah, the attorney fee sanctions, because originally there was awarded, I think it was $3,500 in sanctions for the, at one point in time, but they weren't told that that's what it was for. They were told by Moster that the purpose of it was that they just needed to pay that and they weren't told why. And he didn't understand why at the time and just did what he was told and wrote the check.
Well, hell, they can send me a bill for that and I'll reimburse them. Or the firm will. That makes sense legally. But for things that are accrued after the firm withdrew, I mean, we're not allowed to serve those responses.
When you're attorney of record?
Well, we're not attorney of record after March 3rd.
After, yes.
And it's $1,000 a day after
pretty fine
that.
point to skate on there. Yeah. Anyway, who else has something to tell me?
I have nothing further, Your Honor.
Nothing further, Judge.
Cotton?
No, I don't have anything else.
Okay. Well, I've been thinking about this case, not for a whole year, but yeah, for a week or two. And I believe I agree with Mr. Cotton on one point. The $1,000 a day is not in line with not proportional to the wrong done. So I don't think that's correct. The object of a sanction is to make the other side whole for the efforts they have to expend because of the behavior of the defendant in this case. And I understand that. I am somewhat amazed at Mr. Cotton's position that he's not responsible for anything that happened afterwards when it all happening because of the apparent neglect of his law firm. So that's why I said it's kind of a fine point to raise. I believe that the sanction ought to be $20,000 for the time expended by Mr. Billick's firm. I spent a couple of days getting yelled at by partners in your firm earlier in the week.
I'm sorry to hear that. Was it Boone, Judge? I'll yell at him. Boone could be a little loud.
He was excited. It was about attorney's fees, so he was excited.
Good deal.
And I am going to assess that against both Moster and the builder here, Greystone, because and if Moster doesn't pay it, Greystone may have a claim for reimbursement from the Moster firm. That's not for me to decide today, but it certainly sounds like it to me. And payable within 60 days sounds perfectly reasonable. And have we got the discovery in hand now? It's finally done.
Yes, yes. The initial round's complete. Ms. Wellborn, I will. She and I maybe disagree on a lot, but she was very quick and expedient on getting what I needed, and so I look forward to continue working with her despite our differences of opinion.
The prospect of $1,000 a day for inaction is, a spur. So, and the admissions are still deemed admitted.
It's kind of an up in the air. She responded, and I told her I would work with her on that. So I'm not in the game. I don't play games of gotcha, Judge. And so even if there's a technical thing where they have not yet been deemed unadmitted, we'll work that out upon the trial.
That's the most serious problem in a case is having deemed admissions.
Yep.
And we're well together.
I have seen a few cases where the attorney sending the request for admissions does admit you ran the red light, admit that you didn't run the red light, admit that you were speeding, admit that you weren't speeding. It boggles the mind why there's a particular law firm that at least used to do that years ago. And I never knew what to do with those because you've admitted it was white, it was red, it was black, it was whatever. Don't know what color it was. Okay. Draft an order that says that, get everybody to sign it, approving it as to form, and I will sign it when it hits the submission box at county court number, because I'm actually working in county court this week. So county court number 2. 2. Anything
Judge,
else we can do today?
I believe it's going to be an amended order, right? Would that make the most sense? So that way it
Yes.
amends the
Amended
previous.
contempt order. Yeah.
Okay.
All right.
Thank you, Your Honor.
Thank you, Judge.
Good luck to y'all.
Thank you.
Good to see you on the bench.
God's benison be upon you.